How to name guardians for your children. It may not be who you think it is. How to name guardians for your children. Step 1. If you're married, it is very, very important that you and your spouse are in sync on this decision. It is very common that people come into our office and we have a meeting to discuss who we're going to name for guardians for their children, and they don't agree. We have a whole process in place to help people get into agreement. And I need everybody to understand that this is something that is very easy to change over time as your facts change, as your life changes, as your children grow and change. And also that a B+ decision in this case is way better than a 0. A B+ decision here will get us so much farther in the event that we actually need to use these documents than having nothing in place. Let's talk about what happens if you don't have anything in writing where you've nominated guardians for your children. What happens is that people will step forward to apply for guardianship through the probate court process for your children. And the probate court judges, while they're very well-meaning, they're going to take a look at the applications and they ask things about credit history and jobs and who are the other children in the home, where's the child going to be physically located. It's a good starting place to make a decision, but it is by no means a comprehensive hours-long, weeks-long assessment. So they're going to take a look at the people who have applied, and they're going to use some pretty cursory information to make a decision as to who should actually be appointed guardian over your children if you do not make that nomination for yourself in writing in a legally permissible format. Now, if you don't want to go through that process where a court or a judge is going to decide who is going to be in charge of your children if you cannot make decisions for yourself, then here's how you, in advance, name guardians for your children. You need to make a last will and testament. And in that last will and testament, you are going to nominate guardians for your children if you cannot do that for yourself. So if you are not able to be the parent for whatever reason, then we need to have people who have been nominated in writing. And in Ohio, a last will and testament has to be witnessed before 2 disinterested witnesses, meaning that they're not related to you and they're not named in the document. And then that document is legally valid, and it is a format in which a court will recognize as a guardian nomination. Here's the thing, though, is that you need more than the last will and testament, because what if you're not dead? What if you're not gone? What if you're just temporarily incapacitated and you need somebody to temporarily step in to care for your children, and you don't want Child Protective Services involved in this decision? Well, we need to also make temporary guardian nomination forms that say, dear world, if I am incapacitated but not gone, here is the list of people who are permitted to take my children overnight and make decisions for them. And remember, we don't need A++ decisions here. If you and your spouse don't agree, having a B+ decision is so much better than a 0. First, it's unlikely that this happens, but it is critical that if it does, we have the right documents in place to care for your children. Let's review your plan for your children's future. To get started, you can visit our website at boonelegal.com or give us a call at 330-968-6003. We look forward to helping you.